Hi, I'm Courtney from the Wayland Library, here to welcome you. Thank you for coming out this afternoon. I just want to say a quick thank you to Angela Crocker and Shauna Levine. Angela of the Parmenter Foundation and Shauna from the COA. This program and this series of programs is a collaboration between our 3 organizations, and I hope you'll join us for the next 2 programs. Also, a little library plug. We are doing strategic planning and need your input. So we have a survey and there are handouts over there. And now I will hand it over to Sean, who's there for Nobby.
Thank you, Courtney, and thank you, Angela. It's been great working with both of them. We are so excited to have our first program today, and it is on estate planning. And we'd like to welcome back our good COA friend, Denise Yurkofsky. Denise is an elder law attorney. She also happens to be on our board. So she's been doing these programs for us for many years, and they're always, how many? 20 years, wow. So we're so happy to have her back. I just also wanted to mention that we have quite a few people joining us via Zoom today as well. And when we finish the program, we'll probably take questions from our Zoom audience first, just to make it a little bit easier. We have muted everyone on Zoom, but you'll be able to unmute yourself if you would like to ask a question. So without further ado, here is Denise Yurkofsky with our estate planning program.
Thank you.
And just to can you hear me? Just to reiterate what Shauna said, if you could hold your questions to the end, I think that would be very helpful for everybody. Okay. Good afternoon. It's great to see you all. This is a wonderful turnout. As Shauna said, I've been involved with the COA for many years and have seen firsthand how much it helps people at different times. And so I'm very grateful to be part of it and looking forward to the new community center that should be coming soon.
Denise, excuse me, but I think it would be good if you use the...
Okay.
Yeah, and you have to hold it up close to you. I think it is on, yes. Let me just, yeah, it is on. So if you can just put it close.
Sure.
Just so the people, because we have a lot of people in the back, so that would be great.
Okay.
Thank you.
I want everybody to hear. And if you can't hear, raise your hand, okay? If I'm saying something and you can't hear me and want me to repeat it, just raise your hand, okay? So I'm here today to talk about estate planning with a little bit of a focus on elder law. I'm an estate planning attorney and an elder law attorney, and for many years I had a small practice here in Wayland, right across from the post office. And I recently closed my practice and moved to a larger firm as part of my transition to retirement, because I'm retiring next year. Being here in Wayland, was a very important part of my practice. Can everybody hear?
I think you're having a hard time.
Okay, is that better? No. Yeah, that's better? Okay.
Yes.
So I'm here to talk about estate planning. And some people say, estate planning, I don't need that. I don't have a lot of money. Why do I need that? And it's really important for everybody to have an estate plan. Because if you don't have one, then you're losing control. So estate planning addresses what happens if you become incapacitated. If, because of some medical condition, you can't make decisions for yourself, you can't manage your affairs. There are certain documents that you can use, and we will talk about them in greater detail, so that you can name whom you trust, the person you want to act for you in those situations. Estate planning also deals with what happens at your death. You're planning, and the goal is to make it as smooth, as easy as possible for whomever you leave behind, whether it's family, whether it's friends, the people you care about, your loved ones. You want to set it up so that it's easy for them to handle. You don't want to create unnecessary burdens for anybody. Sorry, I've got a lot of contraptions here. Okay. So by having an estate plan, you're controlling who you want to handle your affairs, who the right people are, who should receive your property at your death, You might want to provide in special ways for minor children or for beneficiaries, people you care about and are providing for who might be disabled, who might be spendthrifts, might not be good at managing money. Sometimes there's extra steps that you want to take to provide for them in the best way. And you also want to think about minimizing estate taxes. That's another component. And you want to provide liquidity so that there's money there to pay for funeral expenses, administration expenses, any taxes that are due. So these are all things that we think about in putting together an estate plan. There are certain documents that are typically part of an estate plan. First of all, you have your documents that deal with incapacity. So you have a healthcare proxy, in which you name someone to make medical decisions for you. And you might have a living will, which is not binding, but it explains what your wishes are, about end-of-life care. And you might want to have a HIPAA release, which gives access to your medical information to certain people, which can be very helpful in an emergency. It's also very important to have a durable power of attorney, which is for legal and financial matters, and we'll talk more about that. Everybody thinks of a will as part of your estate plan, and that certainly is a very important part of your estate plan, regardless of how much money you have, what your assets are. It's important to have a will in place. For some people, they like having a trust. They want to have a trust, and there are different reasons for having a trust, and we will talk about them in more detail later on. Everybody who owns a home should have a homestead declaration on record. And so these are the documents that make up your estate plan, and you should review them periodically because your situation changes. People sometimes come to me and say, I have this will from 1987, can I still use it? And maybe they can, but in most cases, it's just not appropriate anymore if their situation has changed and they need something different. So you should look at it every few years to make sure that the people you named are still the right people to act for you, and that the people you are providing for are still the right people, the people you want to provide for in your will. So, I'm going to go through each of the documents in more detail. So a will is a very formal document. The law has requirements for the will. It has to be witnessed by two people who are not beneficiaries, who are not named in the will. It directs who will receive your property at your death, but only your individually owned property. So, and we're going to talk a little bit more about what that entails in a minute. The will also designates who you want to name as guardians if you have a disabled child or a minor child. And you also designate who you want to be the personal representative. This is the name that's used now for what used to be called executor. It's the person who gathers the assets and just, pays any debts, pays any expenses, pays taxes, makes sure all the tax returns are done, and then distributes the property in accordance with your will. If you don't have a will, then state law says who will receive your property at your death. And it may not be the people you would want to receive your property. So that's why it's important to have a will, so that you're taking control. You're making sure that what happens at your passing is consistent with your wishes. Okay, the next document is a durable power of attorney. And it's a very important document because if you don't have it and something happens to you and you're incapacitated and you can't pay your bills or handle your affairs, somebody has to be appointed by the probate court to do this, and that person's called a conservator. And it's an expensive, long process, and it's essentially you lose the ability to say who you trust the most, who you want to handle your affairs. So everybody should have a durable power of attorney. When my children went off to college, I had them sign a durable power of attorney. Everybody of every age should have one because things could happen to any of us. In the durable power of attorney, you're authorizing somebody to act for you legally and financially, to pay your bills, to enter into contracts if you need caregivers, to pay your mortgage or your real estate taxes, and to essentially handle your affairs, your legal and financial affairs. Typically, it's effective immediately. That is what a durable power of attorney is. It survives your incapacity. And a lot of people say, well, why do I need it to be effective immediately? Why can't it only become effective when I become incapacitated? And there are powers of attorney like that. They're called springing powers, and they're only effective when you're incapacitated. But in a time of crisis, the person you named has to go to the doctor and get a letter of incapacity, and at every turn has to establish that you are indeed incapacitated. So at a time of crisis and stress, it creates much more stress. So most people prefer to have a durable power of attorney that's effective immediately. So if you're on a trip and you need someone to deposit a check for you, even though you're fine, but you just happen to be out of the country or in a different state, the person you've named on the power of attorney can endorse a check for you. So it can be very convenient to have it effective immediately. And the other side of that is if you say, I don't want anyone to have that power while I'm fine. Well, if you don't want them to have the power when you're fine, do you want them to have the power when you're incapacitated and can't check on anything? I would think that that's when you really want to make sure you have someone you trust. So I think it can be very helpful to have one that's effective immediately. It can be as broad as you want it or as limited as you want it. Some of them say, I allow my attorney, in fact, to make gifts, and others don't. It's whatever you want. You have a lot of control over what you're doing. You can revoke it anytime you want. I had somebody call saying, I named my daughter, but she's really into my affairs. She's much more involved than I want her to be. I'm fine. I don't need her taking control right now. I think my son would be much better. And so it was very easy to make that change. The person you name as agent is called the attorney in fact. And that person is a fiduciary. They're acting for you. And they have to act in your best interest. They can't take your money for themselves. They can't, do what they think is best. They have to do what's in your best interest. And that's really important. So if you're, signing a durable power of attorney and naming somebody, make sure they know that they have this obligation to you. It's a higher obligation than they would have to themselves, than you have to yourself. They have to act in your best interest. It's a very serious obligation that they're taking on. So the most important thing here is appoint somebody you trust. It doesn't have to be a lawyer. It doesn't have to be, somebody who has is financially savvy. It should be somebody you trust who will go to the right people for advice if needed. The next document is the healthcare proxy. And I know that they have sessions here, actually for the powers of attorney and the healthcare proxy, where you can come in and sign it here at the Council on Aging. There are forms online. Your doctor's office has forms. Everybody should have it. If you don't have a healthcare proxy and something happens to you, you're in a car accident or something even temporarily happens to you, nobody can make medical decisions for you. Somebody would have to go to probate court to be appointed as your guardian. And that, again, is a complication. It's really an onerous process that you can avoid by having a healthcare proxy in place. In Massachusetts, you cannot name two people to serve at the same time. You can only name one person at a time. But you can say, I appoint my friend June, and if June can't serve, I appoint my friend Robert to serve in her place. So you can have people sequentially, just not at the same time. And that's because the medical community wants to take orders from one person. They don't want different people telling them what to do. They need one spokesperson. In reality, the person who is your healthcare agent often will communicate with family members, anybody who's affected, and there'll be an open discussion, but it's the healthcare agent who makes the final decision and communicates it to the medical team. If the person you name doesn't want to do it, for whatever reason, they can resign. They don't have to do it. And you can limit their authority. You can say on the healthcare proxy that you don't want them to be able to do certain things. For example, you might say, I want to, especially about end-of-life care, you may have specific wishes that you can put limitations in the healthcare proxy. In most cases that I see, if you're naming somebody you trust and you've talked to them about your wishes, and they know how you feel, they know what you want, and you trust their judgment, what to do in a situation that you haven't discussed, then you probably don't want to limit them because, medical technology changes all the time. You don't want to tie their hands, for situations that you can't really anticipate. So generally, most people, if they trust the people they're naming, they give them unlimited authority, but you don't have to. And again, the agent has to follow your wishes. So if you're a Christian Scientist and the person you name as your healthcare agent is not, they have to respect your wishes. They have to do what you would want, even if it's very different than what they would want. Okay, you don't want to necessarily appoint somebody just because they're a doctor or a nurse or have background if they're not going to follow your wishes, if they're going to be more aggressive than you would want them to be. It's really important to appoint somebody who will follow your wishes. Sometimes people say to me, who should I appoint? I have 3 children. What should I do? And I say, choose the one who will follow your wishes. Doesn't matter if they're the oldest, the youngest. Choose the one who will listen to you and follow your wishes. There's a document called a living will or an advance directive, and it's really important. In fact, this is a really important part of the process. A living will is not binding in Massachusetts, but my understanding is that there's a lot of talk about maybe making it binding. And it's a document in which you say what your wishes are. So some people, after thinking about it and talking to the family about it, they might say, gee, if I have a terrible stroke and I can't converse with my family anymore and I don't recognize people, or if I have advanced Alzheimer's and I don't recognize my family and I can't participate in life the way I used to, maybe I don't want certain measures to be taken. If my quality of life has decreased so much that I don't have what to me is a meaningful quality of life, then you might say, I don't want aggressive measures to be taken to postpone my death and prolong the process of dying. Or you might say, I believe in miracles. Keep me alive at all costs. Do everything you can to keep me alive. It can be whatever you want. So the most important thing is that you sit down regularly, every year or 2 years, with the people you name as your healthcare agent and tell them what you want. Because people's wishes change. You see a friend go through an experience, it impacts you. It might change how you feel about it. I did have a client who said, I believe in miracles, keep me alive at all costs. And we put exactly what she wanted in her living will. And she came back, I think 4 years later and said, I'm ready to change that. I've seen that and that's not what I want. So it's, you can change it anytime you want because people change. Their attitude changes, their wishes change, and it should reflect your wishes. Now, you see here, communication is key. The most important thing is talking about your wishes with your healthcare agent. I call these caring conversations. If you care about the people you're giving this responsibility to, tell them what you want, because it's a very hard role. It's very hard to make these kinds of decisions for somebody else. And if you're doing it without any guidance, you can leave somebody with second thoughts. They can doubt what they did. They can, it really is not fair to them. You have to tell them what you would want in different situations and be as explicit as possible, so that they can follow your wishes and have the comfort of knowing that they're doing exactly what you told them to do. So think about it. It's a big responsibility that you're putting on somebody else. Make their job easier by giving them as much information about your wishes as you can, detailed information. And you might say, the way it was handled in this situation, Uncle John, everything he did with his illness, everything his family did, that's exactly what I would want, or that's not what I would want. Be as explicit as you can. Use examples. And you should, as I said before, you should do this periodically because your wishes can change. And, talk to your friends about it. Everybody has different ideas. These are resources. One is the Conversation Project. It's online, and I put the link there. And it's great for, how to start the conversation. Because clients will say to me, oh, I tried to talk to my daughter about it, and she refuses to talk about it. She won't talk about it. And this helps you get over that hump. And, I tell my clients, tell them your attorney won't let you sign your documents until you have these conversations, But it's really important. Think about it. It's in some ways, it's more important than the money. It's more important. This is for you while you're alive. So make sure that it's what you want. There's a wonderful book called Being Mortal by Atul Gawande. And many book groups read it. It's very popular, and he writes beautifully. And he talks about different situations. He talks about his wife's grandmother and what she wanted. She wanted to be independent. She preferred to live independently and not, even if it meant that she didn't live as long. Because, she wasn't in as safe an environment. She had her little throw rugs everywhere and stairs. But this is what she wanted. And some people prefer to be someplace where they're very safe. Everybody has a different preference. And he talks about that. He also talks about his father, who had a terrible neurological illness. And his father said, please help me navigate this. And by coincidence, Atul Gawande had a colleague whose father had the same illness. And the colleague's father said, if I can sit on the couch and watch football and eat chocolate ice cream, that's good enough. And Atul Gawande's father said, not for me. If I cannot have a meaningful conversation with my grandchildren, the last place I want to be is on that couch eating ice cream. So reasonable minds can differ. There's no right or wrong, and you just have to reach inside and figure out what you want. But this is a great book to read. It's a wonderful book. It's worth the read. And I'm sure the library has many copies. Another resource is 5 Wishes, and it's a pamphlet. It's online, and it asks lots of questions, and it helps you tailor your own living will. And finally, I like the American Bar Association Toolkit. It asks great questions. It has it's just a different format, but it's another way to help you figure out what you want. So you may want to check these out.
It was a little hard to hear you.
Oh, I'm sorry. I missed your hand. I'm sorry. So we just talked about living wills and having conversations with the people who will be making decisions for you to make sure they know what you want. You can also talk to your doctor about it. You should also talk to your doctor about it, because who knows better than your medical team about what your particular situation is and what might be ahead for you. There are forms that you can complete with your doctor or physician's assistant or nurse practitioner. It's called a MOLST form. In some states, it's called PULST. It's medical order for life-sustaining treatment. This is what we used to think of as a DNR, except it's expanded. It talks about, would you want dialysis? Would you want to be on a respirator? And it really, helps you think through some of these questions. So you can always talk to your doctor about this. You can, or somebody on your medical team. Okay, so I think we've covered medical decision-making for end-of-life wishes or for chronic illness, and the legal and financial documents. I mentioned earlier trusts, and I said some people, will want to include trusts as part of their estate plan, and other people may not. There are two kinds of trusts, basically. One is revocable. That's a trust that you can change anytime you want. You can amend it, you can revoke it, you can terminate it. The other kind is irrevocable, one you cannot change. And you should, before signing an irrevocable trust, you should make sure you understand it completely and that it is exactly what you want, that you understand the consequences. And irrevocable trusts are used in limited situations. They're used sometimes for gifting, if you're trying to reduce your estate tax liability. They're used to qualify for Medicaid, for mass health. In certain situations, they can be used for life insurance policies. So there are many reasons why you might use an irrevocable trust, but typically it's for estate tax purposes or to qualify for Medicaid mass health, which I'm not going to be covering today, but that's a program in itself. In general, most people use revocable trusts that they can change anytime they want as part of their basic estate plan. So why would you do that? And a lot of people say, what is a trust? A trust is, it's a way to hold money. And you appoint somebody as the trustee, and that can be you. That's the person who's in charge of the money, how to use it. And then you have the person who creates the trust. That would be you too, if you're creating it. And then you have the beneficiaries. So those are the three roles: the creator of the trust, the person managing the trust, the trustee, and the beneficiary. Typically, during your lifetime, you would be the beneficiary, and then the trust would say at your death who you want to receive your property. And a lot of people say, well, why would I do this? Why isn't a will good enough? And a will is fine. But a will has to go through probate. So, I am going to talk about probate in a minute, but one of the benefits of using a trust is that if you are diligent and get everything in the trust that should be there, you can use it as part of a plan to avoid probate. You can also use a trust to reduce your estate taxes for a married couple. There are ways to shelter the exemption amount of the first to die, and those are called AB trusts or credit shelter trusts. Often you might want to use a trust if you want to provide for somebody who's disabled or who can't manage money or who is a minor. And if you want to provide for somebody who's disabled, there's a special kind of trust that's used called a supplemental needs trust. And this is so that you can leave an inheritance to that person, but it's managed by somebody else. And if drafted a certain way, the money, that inheritance, the money that's in that trust, will not cause them to lose their eligibility for any public benefits they're receiving. If they're receiving SSI or mass health, it will not cause them to lose it will not be counted in terms of figuring out if they're eligible for those benefits. So anybody who wants to leave money to somebody who is receiving public benefits should look into supplemental needs trusts because they're very effective and a very good way to provide for somebody.
Could you say the name of that again, please?
Sure, it's supplemental needs trust.
I see it. Thank you.
Okay, it's right there in the third bullet. Okay. So another reason for using trust might be creditor protection. If you're worried, if you have a child who's an ER doctor or you think might get divorced, a trust structured the right way can be helpful in protecting that person, in providing creditor protection. So that's another reason why you might want to think about using a trust. But often In most cases, it's used because it's used to avoid probate, and it's used, to provide for minor children or younger children who aren't yet mature enough to handle money themselves, or for particular beneficiaries who need to have somebody else manage their inheritance for them. I talked a little bit about estate taxes and minimizing estate taxes. And there have been changes over the years, so I want you all to understand what estate taxes are. So at your death, somebody has to look at everything you owned at your death. And we gather what we call date of death values. So it's as if somebody takes a snapshot of everything you own on the date of your death. And in Massachusetts, if it's $2 million or more, an estate tax return has to be filed. And it's due 9 months from the date of death, but you can get an extension for 6 months. And if there is tax liability, that's due 9 months from the date of death. It's always helpful. You shouldn't make that, you really should find out what the rules are and work with a professional in determining whether an estate tax return is required or not. And you do have to include jointly owned property, retirement accounts, or your interest in the jointly owned property, retirement accounts, annuities, life insurance policies, your cars, your personal property. It's money that you have in bank accounts, investment accounts, retirement accounts. So it's very, it really covers everything that you have an ownership interest in. For Massachusetts purposes, the number is 2 million. It used to be 1 million. It increased to 2 million recently, last fall.
That includes your house?
Yes, includes your house. Yeah. So around here, it's not hard, yeah. For federal purposes, the good news is that you currently have an exemption of $10 million, indexed for inflation. So this year it's $13,610,000. And if you're married, at the first death, let's say you only use up $3 million of your $13 million exemption, if a federal estate tax return is filed and you do something called electing portability, which I know is complicated and we're in the weeds here, but just know that the surviving spouse can get the benefit of the deceased spouse's unused exemption amount. You don't need, the bottom line here is just understand that this is something you should think about if you're a married couple at the first death. And if you go to an attorney, the attorney will talk to you about it. But it's something to consider. Now, you may say, oh, I'm never going to have $13 million. I'm not worried about it. Under current tax laws, the federal exemption is scheduled to go down to $5 million in 2026. It'll be indexed for inflation, so we think it'll be around $7 million. But it's reduced because it was increased from $5 million to $10 million. And it was only for 10 years. So when the 10 years is over, it sunsets and it goes back down to 5 million. So if with inflation, it's probably going to be 7 million. It's still a very high number. And for a married couple, you can, by electing portability, you get twice that. So it's just something to keep in mind. There is an unlimited marital deduction for anything passing to a surviving spouse. So if you have a retirement account, and it's $100,000 and it passes to your spouse at your death, that is not going to, you may have to, you still have to file the return if you're over the 2 million, but there's not going to be a tax on that. There's an unlimited marital deduction. So if you leave everything to your spouse, everything, you may have to file an estate tax return, but there would be no tax owed on everything that passes to the surviving spouse. There are also charitable deductions. You get deductions on what you give to charity at your death. And as I said earlier, there are ways to use trust to minimize your potential estate tax liability. And that's more sophisticated estate planning and kind of beyond what we're looking at today, but it's just something you should be aware of. Okay, a homestead declaration, which I mentioned earlier, is something that gets recorded at the Registry of Deeds, and it has to be filled out carefully. And if you record it, then it gives you, it protects up to $500,000 of the equity in your home. If you're under 62, then you have a homestead for the family. If you're over 62, you could have your own homestead. So for two people living together, they can each, if they're over 62, they can each have a homestead. If they, and that way you can have up to $1 million of creditor protection between the two of you. It doesn't protect you if you don't pay your real estate taxes, if you don't pay your mortgage, or other secured indebtedness. And if you are getting Mass Health and Mass Health has a lien on the property, that supersedes the homestead as well, or estate recovery. And again, the elder homestead is 62 and over. And it's a very basic form. It has to be done correctly, but everybody should have it on their house. If you don't have one, there's an automatic protection of $125,000, but why not get the $500,000? We could all be in a car accident or be sued for something, and it just protects your home. Okay, I said earlier that we're going to talk about probate and when you have to worry about probate. Probate is not a terrible thing. It's just that there's added expense and delay when probate is involved. It means that you have to go through the probate court and provide notice to certain people. So probate is the process for transferring individually owned assets at your death. As I said, there's a cost to it. There's a lack of privacy. Your will becomes public record at the probate court. Your assets become public record. So there is a lack of privacy. And here's the important part. You don't need it for property that's in trust. Property that's in trust does not have to go through probate, and that's one reason why people use trusts. Jointly owned property passes automatically to the surviving joint owner, so it does not go through probate. So if you own your home jointly with somebody else, you pass away, they become the 100% owner automatically by operation of law. If you name beneficiaries, property passes to the beneficiaries without going through probate. So think about your IRA. You name, let's say you have an IRA and you name your two children as the beneficiaries, and the IRA is at Fidelity, let's say. You pass away, your children, establish your death with the death certificate, and Fidelity pays the money directly to the children, the beneficiaries, in accordance with that form that you filled out, the beneficiary designation form. So anything with the beneficiary does not go through probate. You can also have accounts, investment accounts that are called TOD, that means transfer on death, or bank accounts that are POD, payable on death. And these pass directly to the beneficiary you've named. And there's just something to be careful of here. Some people say, oh, okay, I have 3 children, I'm going to put my daughter on all my bank accounts so she has access to my money and can help pay my bills. And, I'm going to name, different people as beneficiaries on all of my accounts. And it might be that your goal is for each of your 3 children to receive the same amount. But as beneficiaries, they're going to receive what's in that account that has their name on it. And it may be that they don't get equal amounts. So if you really just have to be careful that you're not acting in a way that's not consistent with your estate plan. Life insurance also has beneficiaries. And so life insurance typically passes automatically to the beneficiaries if the beneficiary is alive. So to sum up, the only property that would have to go through probate is property that's in your name individually at your death. Okay, not jointly owned, not in trust, not with the beneficiary. If it's just a car and maybe, some refund checks, and it totals less than $25,000 or less, not including the one car, then you can do what's called a voluntary administration. And we often have to do this. It's not a big deal. It's one form that gets filed. It takes about 3 weeks. The filing fee is slightly more than $100, and this is very routine. If you have more than $25,000, then you have to do either an informal or a formal probate. If real estate is involved, typically you want a formal probate. There may be situations where informal is fine. And the only difference is that the procedure is a little different. The cost is about the same. The informal is quicker, but it doesn't give you the certainty that the formal has. So if you thought there was going to be a will contest or that there were problems in your estate, you would want to do the formal, just to have the court say, bless your will. But in many cases, the informal is fine. And so that's something to discuss when the time comes and make a decision. Now, there is a law that says that if at your death you had a bank account that was under $10,000, they can transfer it without going through probate. The reality is that a lot of banks don't want to do that. They're worried about liability. But I have seen it happen. If you're a married couple and one of you passes away and the deceased spouse is the one to own the car, the surviving spouse can go into the Registry of Motor Vehicles and sign an affidavit, and the car will be transferred to the surviving spouse. If you own property out of state in your name individually, then you will have to do an ancillary probate there. So it's really important to check. It's really important to check on how things are owned. When anybody comes to me for estate planning, I give them a questionnaire to complete ahead of time. And they say, why do I have to give you all this information? I don't want to go digging through and fill out this form. And I say that it's really important because it makes a difference. I need to know how everything is titled, because I may say to you, change how it's titled. If you use a trust, you may want to transfer certain property to a trust, or you may want to have certain beneficiaries on the account. So an estate planning attorney will look at all of this and review all of it and make sure it's consistent with your estate plan. We talked about this. So again, to avoid probate, you can use a trust, you can have beneficiaries, you can have joint ownership. Just make sure everything you're doing is consistent with your estate plan or your wishes. Some people say, oh, why can't I add my child as a joint owner on all my property? Wouldn't that be great? Then I don't have to worry about probate. The problem is there are risks to owning property together. If let's say you bring your son on as a joint owner on all of your assets and your son gets sued, your assets are at risk. His creditors can come after your property because he's a joint owner with you. He also could take all the money and run if he were not a nice fellow. And also if you have a joint account, you have to keep in mind that the surviving joint owner, you pass away, you have an account that's joint with somebody else, they become the legal owner at your death, and that may or may not be what you want. You might have meant it differently. You may not have meant to give them a gift. And you should also think about, are you doing, if you're adding somebody as a joint owner, is this going to hurt them in any way? Are they going to be applying for financial aid for a child? For example. So you should stop and think before you add anybody as a joint owner on your account. Many people do it on a small checking account for cash flow, just for convenience, so if they're sick, somebody else can pay their bills. But for larger assets, really stop and think carefully. We talked about irrevocable trusts. Supplemental needs trusts are the trusts we talked about for beneficiaries who are disabled, who are people you want to provide for who might be disabled and receiving public benefits. Gift tax. We're almost done. I know we've covered a lot of ground here, and I really appreciate that you're staying awake and listening. Gift tax, there's federal gift tax, there's no gift tax in Massachusetts. Remember I said you have for federal purposes, you have an estate tax exemption of $13,610,000. You have that same amount as an exemption from gift tax. So you only have to worry about gifts. You would only have to pay gift tax if you give away more than that amount. However, what you give away during your lifetime reduces your exemption at death. So the IRS wants to know whenever you make gifts over a certain amount. So you would have to file a gift tax return even though no tax is due. And you're just doing it to disclose the gift to the IRS. You don't have to file a gift tax return if you're making what's called an annual exclusion gift. And this year, the limit is $18,000. You can give $18,000 to as many people as you want without filing a gift tax return. If you're a married couple, you can what's called gift split, so you can give twice that amount. You can give unlimited amounts for tuition or for medical care. As long as you pay the money directly to the provider. You can't give it to your child to pay the doctor. You have to pay the doctor yourself. And there are special rules for non-citizen spouses. So this doesn't apply to non-citizen spouses. And there's no gift tax for gifts between spouses who are both U.S. citizens. And again, there's no Massachusetts gift tax. So that can be an important part of planning in certain situations. Before making any gifts, make sure that you're not jeopardizing your financial security first and foremost. It doesn't matter if you're saving taxes if you end up not being able to pay for the care that you think you might need. And if you're going to sell stock to make a gift, make sure you're not going to incur capital gains tax that's greater than the estate tax you'd be saving. So that's something to talk to your accountant about. And everybody should understand that if you think that you might have Medicaid in the future, there's a 5-year look back for gifts. So also think about that before making gifts. For some reason, it's not going forward. Maybe I can do it here. Okay. I'm not going to cover long-term care insurance, but it's something to think about. It's a way to pay for long-term care. There's a cost to it, and that's something to talk to a long-term care insurance specialist about. So, just to recap, you should always check your beneficiary designation forms. For life insurance, for IRAs, for your accounts, to make sure they're consistent with your plan. You may have to change ownership of your assets, to avoid probate or to carry out your estate plan. But above all, make sure that whatever you do is consistent with your estate plan. I get calls from clients all the time saying, I don't remember what you told me to do in this situation. What should I do? Is this the right thing to do? And call your lawyer if you have any questions, or your accountant. It's really important to do things consistently with your plan. If you don't have an estate plan, you don't control who gets your property at your death, you don't avoid probate, which could be additional expense, you don't have any control over who the people are who are taking care of your affairs, you lose out on tax planning, and you may not be planning for your incapacity in the way you would wish. So it's very important to have an estate plan for everybody. And usually we work as a team. You have a lawyer, you have an accountant. Some people have, aging life care professionals or care managers. So people work together so that you get the best possible result. Most importantly, don't wait for a crisis. Nobody plans well in a crisis. You don't want to wait until you have a bad diagnosis before thinking about what you want your living will to say, or thinking about your planning. You want to focus on what's going on with you medically and already have taken care of the legal and financial matters. So do it now, just so you're in a good place so that you can weather those crises that arise. And for your family, it's really important to make it easier for your family. And if you take care of things ahead of time before you need to, you're giving an amazing gift to your family because it makes it much easier for them. And you should all know that this is just an overview. It doesn't apply to your situation in particular. Before taking any action, you should talk to a professional who will look at your situation and do what's right for you. Okay? I'm not trying to give you legal advice here. I'm just trying to summarize the different things you might want to think about. Okay? So it was a little longer than I thought it would be. I hope I didn't put you all to sleep. I hope that that this is something that you can carry with you. Questions?
Thank you very much, Denise. That was just great. There's so much information in there. I just also wanted to mention that WayCam is recording this program, so if you missed some of it, you can watch it on WayCam. We will put when it's going to be shown in our next newsletter, so take a look for that, or you can just call us and ask us when it's going to be shown on WayCam. I think what we'll do is start with the questions on Zoom. We'll just stop your share.
Okay.
Okay. Are there any questions from anyone who is on Zoom? Okay. If not, we will just open it up to questions.
Sure. Yes.
I have a question about the estate tax, a mass estate tax exemption, where they come in and they have to look at everything that you own in your name after you're gone, or somebody does.
Well,
Right?
whoever your personal representative is will do
Yeah,
that.
I'll take pictures of everything that's in your name.
It's not.
Wouldn't that be,
They're not really taking pictures. What I mean is that they're looking at everything you own.
and trying to get the value of it?
Yeah, getting the
Okay.
value as of the date of your death.
How does that relate to if you have a living trust or a living will?
So a living trust is a trust that you fund during your lifetime, a revocable trust that's funded during your lifetime.
Mhm.
That is part of your taxable estate. That's included in your taxable estate because you have so much control over it. It's under your Social Security number. You have the right to amend it, to revoke it. You have so much control, it's included in your estate.
How does it relate to, I should think one would, maybe you wouldn't have to do the other if you had one, but I guess you have to do, all right. I guess my question is, no matter what you have in place, this is still a requirement, the mass estate exemption, where anything that you own has to be evaluated as far as the value of it.
Yeah, there's a filing, the requirement for filing is $2 million less any taxable gifts that you made during your lifetime. So if you gave a child $500,000, then that reduces your filing threshold. So the bottom line is you need to talk to a professional about it when the time comes. But essentially, you look and see if the assets are $2 million or more, if the person who died hasn't made gifts. And you determine whether an estate tax return has to be filed. If you're over the filing threshold, then it has to be filed. There may not be any tax due if everything's passing to a spouse or charities. There may not be tax due, but you still have to file. Yes.
A lot of people are surprised when they hear that the power of attorney ends at death.
Oh, that's a good point. It does end at death. If you have a bank account and you have put your attorney, in fact, on the bank account, that person at your death cannot touch that money.
Right.
It's part of it would have to go through probate. So that's an important thing to know. I'm sorry, I should have highlighted that. It ends at death. It's just while you're alive. A lot of people say, oh, I should be able to get that money. I'm the attorney in fact. And I say, no, if your mother's passed away, you can't access it any longer. They essentially freeze the account at the death if it's individually owned. Yes?
I have two hopefully quick questions. One is, does the state restrict any of your agencies to being in-state only? Can I, for instance, appoint someone from outside Massachusetts as my executor or my attorney in fact?
Yes, the answer is yes. You can appoint whoever the right person is.
Okay, the other is, can the 5 wishes document substitute for any of the documents that you mentioned?
I think the 5 wishes document can function as a healthcare proxy, and you could use it as a living will also. They may have separate forms for that. You just have to make sure that you're complying with state requirements, and for a healthcare proxy, it's 2 witnesses who are not named in the healthcare proxy.
Okay, thank you.
There's also, the Mass Medical Society has a healthcare proxy online that's used quite a bit.
Okay, thank you.
Yes.
I was wondering, when does irrevocable trust ends?
Which trust ends?
Irrevocable.
Irrevocable trust, whatever the trust says. The trust document is the roadmap. It could continue for the lifetime of your children. It could end at your death. It could say everything outright to your children or whoever your beneficiaries are. Whatever the trust says, that's what determines how long it lasts.
So it's not a matter of partner is passing.
It doesn't have to end at your death, no.
Oh, okay.
It can be whatever you want it to be. There's a lot of flexibility. Some people have a trust that says, at my death, everything passes to my children in equal shares. Other people might say, at my death, everything is held in trust for my children, and then they get their share at age 35 or whatever age they want. Or you might say, at my death, everything's divided into shares for my children, and it stays in trust for their lifetime. They each have a sub-trust, a separate trust. And there are reasons for doing that. It really depends on your situation. So you have many different options.
What is the best document? You know, I had a situation, my brother passed, and I was responsible for all his burial and other deaths, but I wasn't his beneficiary, so I didn't get paid. Okay, so you know, for next time, what is the best document to give somebody money to pay for all these burial and death expenses? Because
That's a good question. When we were talking about how to avoid probate and putting beneficiaries down, I think I mentioned liquidity, that you need to have money there to pay for the expenses, to pay for funeral expenses. And if you don't, what's going to happen? Some people prepay their funeral, but you still have administration expenses. You have to file a final income tax return. There may be estate taxes. So it's really important to set everything up so that there is liquidity. Typically, it's done if it goes through probate, whatever's in the estate can be used first for funeral expenses and for the estate administration expenses before anything is paid to other people. But that's the risk of using beneficiary designations and not leaving anything to cover all of the expenses.
okay, because at the point of death, his money, like his investments, go to the beneficiary. I can't draw out of that before it's distributed, and that's, I didn't know that, yeah, okay.
So what you might do is just say, okay, don't have a beneficiary on it, so it passes as part of the estate, and then you can access that money to pay the expenses. As the personal representative, you have the right to that money, which is now in the estate, to pay expenses.
I mean, there's a lot of technicality, and it's a family situation too, so I want to get, but yeah.
Things can get very complicated.
And that's why I want to make sure that when I pass, that whoever handles my expenses. There's money goes to this person, before the money is given out to the beneficiary.
So sometimes, so if you use a will, and if it goes through probate, that's what will happen. Because everything will be in the probate estate, and the person who's the personal representative will have access to that money to pay all the expenses before any of the beneficiaries get paid. Or if you use a trust, you can accomplish the same thing.
All right, thank you.
Yes, Shauna?
Denise, we have one question in the chat. How is a testamentary trust different from a regular trust?
Oh, that's a good question. A testamentary trust is a trust that's within the will. So the will might have a special provision that says, the will might say, at my death, I leave everything in trust for my spouse. And then the next article of the will might say, this is how the trust will be administered for my spouse. That's a trust that's within the will. It's sometimes used for Medicaid planning. It's used in different situations. Sometimes people don't want to have a separate trust, and maybe they have younger children, and they set up the trust within a testamentary trust for their children, just in case the children are under 25 when they pass, when they pass. But a testamentary trust is a trust within a will, whereas the other trusts that I was talking about are standalone, they're totally separate. Yes.
Regarding gifts, is it always is it the giver of the gift who may have to pay gift tax? Does the receiver of the gift ever have to pay any kind of tax on it?
Well, I don't want to say never, but in your general situation, there's something called generation skipping transfer tax, but forgetting all that level of complication, in your basic situation, the gift tax is paid by the giver. Okay, not the recipient.
Okay.
And when you inherit money, you don't pay tax on it. If some of what you get is income, you might have to pay income tax on that little bit. That's, let's say if you have $50,000 in a bank account and you leave it to, and in your will you say, I leave money to a certain person, and it has earned some income, some interest, and part of what they get is that interest that was earned, then they might have to pay income tax on that. But it's just a small portion of what the total gift is.
And you said the threshold for needing to pay tax, or the exemption is lowered by the amount of gifts you've given over your life. Now, how is that dollar amount of lifetime gifts established? Is it only when you have to file a gift tax return?
Yes.
So in other words, if your gifts are all under that 18,000, the IRS doesn't even know about it, or whoever, the
Yeah,
tax
the IRS
people
doesn't
don't.
care about it, and
Okay.
Massachusetts doesn't care about it.
Okay,
Your filing threshold is reduced for certain gifts, but
okay.
not annual exclusion gifts.
Oh, okay.
Some people say if I have, if there's a $2 million exemption and I have $3 million, or can I give away $2 million and not have to file a return on the $1 million that's left? And the answer is no, because the $2 million you give away reduces your exemption.
Oh, okay. Thank you.
Yes.
How long on average does it take for a will to be probated, or an estate to be probated?
Okay, in Massachusetts, creditors have 1 year to bring a claim against the estate, so you can't close out the estate before 1 year. And other than that, it depends on how long it takes. If you've got real estate to sell, it might be longer. It really depends what the assets are and how easy it is to collect them and to pay the estate taxes and do whatever is needed.
And during that time, is everything frozen so that?
Sometimes there might be advances that are made, but typically people wait until after the 1 year creditor claims period. Because you could be the personal representative, and if you distribute the money to the beneficiaries and then a creditor surfaces and files a claim, follows all the procedures for filing the claim, then, you're in a bad position. So it's better to, most people just wait a year. In some states, it's a shorter creditor claims period. Yes.
Can you address the validity of irrevocable trust that say was created according to the laws of, say, in the state of Florida, because the grantor was a resident of Florida at the time the trust was created, but is no longer and is now a resident of, say, Massachusetts. How does that impact the duration of the trust?
Okay, the trust, if the trust is created under the laws of Florida, it's governed by the laws of Florida.
Even though
Usually
you're no
within the
longer
trust.
a resident there, and the property in the trust is nothing to do with Florida, it's still governed by Florida law?
Right, that's why people often, if you move to another state, you go to the state planning attorney and you take care of that. You change the situs, you just have a new trust, you move the property, you
But
deal
if you
with that.
don't, it's still valid, and it's just governed by Florida?
So you're saying it's a Florida trust, but it owns property in Massachusetts? You might try to change, there are things you could do. It's really, if it's a Florida trust, Florida law governs, and Florida law may allow you to change the state. It may say you can change the situs of the trust, but that's a little more complicated. That's
Yeah, it
a
is
very
complicated,
detailed kind of
that's why I was
question.
wondering whether it would impact, because, and for Medicaid purposes, for instance, it has to be prepared 5 years prior. So how would that impact the,
You need to talk to somebody about it because you're dealing with very specific situations. For Medicaid, the 5-year look-back period is not when the trust is created, but when the property is transferred into the trust.
okay.
I think we have time for just one more question.
I have a simple question. You talked about different kinds of accounts. You said the POD is payable on death. I missed what the TOD is.
Transfer on death. So generally, POD is for bank accounts, TOD is for investment accounts. But if you just go into the bank or the institution and say, I'd like to name a beneficiary for the account, they'll know how to do it. There's a special form to fill out.
Thank you.
Sure, just a quick, well, I don't know how quick it's gonna be, but on slide 24, you mentioned the step-up basis.
Yes.
Can you explain what that is?
Sure. At your death, you get what's called a step-up in basis for all of your property that's included in your taxable estate. So if you own a home in your name alone, and let's say you bought it for $25,000 and it's now worth $750,000, and maybe you put $75,000 into it. You redid the basement, you did a few things, you made major capital improvements, you fixed the bathroom or the kitchen. So let's say your basis is $100,000. You pass away, it's worth $750,000. That becomes your basis. The date of death value becomes your basis. If your personal representative or trustee sells the house after your death, and they sell it for $750,000, they don't have to pay capital gains tax. So step up in basis is a wonderful thing, and it's a way to avoid capital gains tax.
And so it's important to also record all of the improvements that you made on the
Keep track of
home.
all of the capital improvements. And it's important when you sell your house too, because,
Yes.
it's very important. But, and it's not just for real estate, it's for all of your assets. I've had clients who have an investment account, and they have stock in it that they purchased, 50 years ago, and they have no idea what they paid for it. And they don't want to sell it because the capital gains tax would be so high because it's appreciated so much. At death, they get a step up in basis to the date of death value, so there's no capital gains tax. But you should always talk to an advisor about this and weigh your options and decide what's best.
Once again, thank you so much, Denise. This is fantastic. And I also just like to remind everybody that we have 2 more sessions left of the series. One is on May 29th on medical decisions, and one on Wednesday, June 5th on demystifying hospice. And the next 2 sessions are going to be at the library, also at 2 p.m. We have flyers if anybody would like to take a flyer home with you. And once again, I'd like to thank Courtney Michael from the Wayland Public Library and Angela Crocker from the Harbinger Foundation. It's been great working with them on this program. And thank you all for coming.